For pronouncement of judgment, item 14.
We have allowed the writ appeal requiring the appellants to be paid the diploma scale of pay as of 5th pay commission and thereafter with 1/1/2006 as per the 6th pay commission.
Item 15.
Will dismissed.
Adjournment request, if any, from item number 1 to 9.
Please, Your Lordship. Yes, with due consent from respondents, I want to mention item number 6, Your Lordship.
6.
Lordship.
They are for the respondent.
I am for the appellant. I have
You're for
taken
the-
I have taken consent of the respondent.
Appellant.
Adjourn.
एडवर्टाइजमेंट के बाद में हम लोग करने की टीम टू be over here. That's a possible view.
Obliged.
Please, Your Lordship. I beg to mention item of 4, Lordship. I'm for the appellant. Yes, yes.
Circulated.
Adjourn.
My Lord, one more pair, my Lord, in respect of item number 8 also.
Adjourn.
Lordship, highly obliged.
Mention item 3.
From item number 10 to 13.
May I please, Your Lordship?
Item
I
3.
mention
I'm
item number 9,
mentioning-
Lordship. With the
Sorry.
consent of other side. I am for the petitioner, Lordship. Lordship, may kindly fix a date because there is some urgency.
July.
July. So with little urgency is there, Lordship.
Agency, that's why only July, otherwise you would have posted date in September.
My Lord, with your lordship's leave, may I mention item 3? Can it be possible that if we have it in May, I'll come physically?
Ma'am?
Can it be possible we have it in May and I'll come physically for the matter?
Why
Item 3.
Yes,
Grateful, my Lord.
yes, it is
Grateful.
possible, ma'am. You ask for the day.
13th May, if possible, my Lord.
Which day?
13th.
13th.
Yes, my Lord.
1/3, okay, 13th May. At the
Keep
request
it,
of the
keep
council for
it.
the petitioner, this
Tuesday.
writ petition for hearing, 13th of May.
Grateful. Grateful.
May it pleases your lordship. Lordship, I am for the appellant in item number 13, lordship.
Right.
But here, lordship,
My
what is-
name was not reflected, the
Answer
respondent's
name
name,
is
my
not
lord, I
shown.
missed the file.
You are aware, you are here.
My lord, I was told on the way to the court, my lord. If it could be tomorrow even, my lord, I just need the file with.
We don't have such urgency. Just list in the month of August, after reflecting the name of Mr. R. Majumdar, concept for the respondent.
I'm obliged.
Lordship, for item number 10, with consent from the petitioner side, I favor and adjourn.
Lordship, only I'll fix the date in July, Lordship. If I am permitted, Lordship.
Obliged, Lordship.
Now only 2-3 matters are there. वो भी ले जाओ.
Any other request?
Can you come this side?
May I appeal 5/2025, not date not given, a Supreme Court order has been violated.
let the case be listed on 28 March. For stay.
Private person petitioner in person. Matrimonial appeal. Then what happened? Division.
But it is not listed before this court. This matter is to be heard by another court.
I know, but
Then you please make a mention there. ma'am.
the court, that court, Surana, Honorable Judge Surana is out of station from Monday.
Then you can't tell. One day he'll come.
For urgency stay matters.
What is the urgency?
Supreme Court order has been violated by family.
No, maybe since when it is violated? Since when it is in violated?
Since family court has violated from 19/12/2024. Stay order is very urgent.
When the matter is assigned to a particular day, or you make a mention where in the absence of Justice Surana, the matter would be heard.
Quickly.
Ask them, to make a mention of that court.
Uzari.
Daily list for admission, item 1 and 2.
One of these matters, we are filing this affidavit during the course of the day. madams. Assembly was going on, assembly ended yesterday, madams.
Assurance was given, your lordship.
We are filing it today, madams. It's in the course of filing.
So. The council of the state, let me go away. Has submitted that. The required affidavit is going to be filed today itself. Just after 10 days.
All right.
Item 5 for hearing.
Debt recovery. Debt recovery.
That committee has rejected. Not 60. This is not. Tribunal have gone on a very different. Paraphrase. As assistant and our private southern is 5 minutes.
Mr. Kaya,
And for the respondent, Lordship.
that's why only we are asking you.
Lordship,
How you are justifying this order of the tribunal?
Lordship, Lordship, we come to page 143. Paragraph 11 onward.
Yes.
Narrative. In percent, it is noted that the pursuant to the advertisement published in Employment News Sunshine, applicant was appointed in the post of section officer at Debt Recovery Tribunal, Guwahati, on deputation basis by order dated 9/2/2017. In note 2 of the said advertisement, it has been stipulated inter alia for the post of section officer, departmental candidate having requisite qualification shall also be considered along with outsiders. And in case the departmental candidate is selected, the post will be treated to have been filled by promotion. Then let's see next paragraph. It is noted that the applicant had applied for the post of section officer. One individual, namely Sri Haliram Das, assistant, had challenged the selection procedure before this tribunal by OA number 10. So however, being found ineligible for the post of section officer, his case was rejected and subsequently said Haliram Das was approached the Honorable Guwahati High Court by petition number 20. However, Sri Haliram Das has withdrawn the said petition with the liberty to challenge the selection of the applicant dated 9/2/2017 as well as 21/2/2017. However, Sri Das never challenged the same. Sri so Leonard CGC for the respondent at the relevant time for appointment of the applicant. The presiding officer was appointing authority and said presiding officer by letter dated 35/2019 had recommended the case of the applicant with the following observation. In this connection, it is been pertinent to mention that since the post of section officer was not filled up for more than years and remained vacant for a considerable time, the same was abolished by the ministry in 2016. Thereafter, efforts were made by this tribunal to revive the post of section officer, and finally the same was revived on 24 January 2017. For filling up the post of section officer, the decision of the selection committee was opened. And with the approval of the Honorable Presiding Officer, offer appointment was issued to Sri Bansidhar Mahapatra, Assistant DRT Cuttack, with a direction to report for duty as section officer on deputation basis and latest by 28/7/2017. And his appointment was subject to the outcome of the writ petition number 20 filed by Haliram Das, Assistant before the Honorable Guwahati High Court. In this connection, it is mentioned that though Sri Mahapatra was a departmental candidate and selected for the post of section officer, he was appointed in the post of section officer on deputation basis, taking into consideration the pendency of the writ petition before the Honorable High Court and the prevailing circumstances as such as the post may again abolished by the ministry. Further, in the event of any order passed by the Honorable Guwahati High Court in the writ petition number 20 by Sri Haliram Das regarding selection and appointment of the post of section officer may create legal complication. Since the meantime, the recruitment rule 2001 was amended and superseded by new recruitment rule of the Debt Recovery Appellate Tribunal, Kolkata, and Debt Recovery Tribunal at Hyderabad, Guwahati, Kolkata, Visakhapatnam, Siliguri, and Cuttack. Recruitment rule 2018. Therefore, filling of the post of section officer, it has been stipulated inter alia. Then it is mentioned, Lordship. Then Lordship, paragraph 15. Then the rule has been quoted. From the perusal of the above rule, vis-a-vis the recommendation of the presiding officer, who at the relevant time of relevant point of time of the accounting authorities had made it clear that the applicant was appointed on deputation basis, since one writ petition supra was pending at the time of his appointment, and for long time the aforesaid post of section officer was lying vacant due to non-availability of appropriate person. However, after promulgation of 2018 rule, all the DRTs were.
We have already gone through the judgment.
Lordship, he was working in the DRT Cuttack, Lordship. And not has Lordship been seen that any department he will be his appointment will be treated as a promotion.
So why you have drawn this deputation allowance?
No, Lordship, that has been taken care by the Land Tribunal. So
What he has said,
Lordship, last line.
and
However,
with
the
your
applicant has
admission that
already-
my parent department is other than this tribunal.
No, Lordship,
There is your admission.
no,
Page 76.
that was earlier, Lordship. Thereafter, he appointed in DRT Cuttack. From there, he
What do you
appointed,
mean by earlier?
Lordship, my affidavit may kindly be seen. I have given all the details. And 2018, since 2018, combined rule has been applicable in case of TRT. All the TRT come under one. And
Since 2018, it's okay. But your appointment of deputation was prior to that.
no, Lordship, that point has been taken care by the landed tribunal also.
How they have taken care?
And that has been recovered from me also, Lordship. That amount has been. Lordship, last paragraph, page 151,
Yes.
last two lines. Therefore, in our considered view, selection and appointment of the applicant to the post of section officer would be treated as promotion instead of deputation with all consequential benefits. However, as the applicant has already availed deputation allowance, he is therefore liable to be refunded back the said amount, or
That
it
is
can
not
be.
that is for that purpose, that you yourself have accepted the deputation allowance claiming that my parent department is so and so.
DRT quota.
Yes.
And Lordship, my further submission, Lordship, the DRT, all the DRTs were under the finance ministry. All the rules were separate, Lordship, at the relevant time. And Lordship, deputation means if a person is to be deputed in some other department, not in the parent department, in the same department. It has already been clarified by the Supreme Court in one of the.
So that's why only deputation itself, you treat deputation as a promotion. It itself is against the very
No,
basic service jurisprudence, sir.
No, Lordship,
How can we treat a deputation as a promotion?
no, Lordship, here, Lordship, situation was peculiar. Because he was appointed in the DRT, although in Guwahati.
So what do you mean by peculiar?
No, Lordship.
You yourself are admitting my parent department is Cuttack, DRT Cuttack, and I am here on deputation.
No, that is there, Lordship, but when I file my representation before the appointing authority at
Sir,
Guwahati.
he may have recommended your case erroneously or in misconception. How it is binding on the courts?
No, that is there.
Ultimately, the committee has rejected your whatever the claim.
No, at the relevant time, but Lordship, since 2018. In that case, Lordship, since when combined rule has been framed, so since 2018, my case is would be on different footing, Lordship. And I filed one affidavit, bringing on record.
Yeah.
Here I have annexure 1, which is order dated 25/7/2019. Some of the juniors, they were appointed, they were also on deputation. They were given benefits, so from that date I am entitled to in that sector.
Order is it?
No. Much of it.
Item 7.
Sir,
my lord, the issue is, my lord, whether the contractor would be entitled to payment for, my lord, carrying transportation, my lord, without having any loading in the truck, without any fee. That is the point, my lord, that I wanted to deduct. That is the finding of the committee. Because in fact, what was entitled, the petitioner is entitled under the contract is, my lord, transportation per metric ton per kilometer. So if the vehicle is not loaded, there is no question of per metric ton. That is the, my lord, the terms of the contract. Your lordship will kindly have a look at the page 129. what we are seeking to deduct, my lord, 129. That is the committee report. The finding, the committee was asked to, my lord, see the distance, how the distance of 7 kilometer. My lord, in fact, first is distance moved by empty trucks from Ramudak Way Bridge after taking the Tairway to meet point of railway siding, 1.4 kilometer. This is exactly which we are seeking to deduct, my lord. Empty trucks. Next, distance moved from loaded trucks from midpoint of railway siding Tinshukia to Ramuddong Way Bridge. This we are giving. Distance moved from loaded trucks from Ramuddong Way Bridge to Laipuli Way Bridge. This also we are giving. Out of this 6.7, the total 1.54 kilometer payment we are not giving because they are only entitled to transportation of the food grains, but are not carrying the trucks in empty from Weybridge to the railway siding. This is the dispute, my lord. And if lordship kindly have a look, he has quoted his rate, my lord, per metric ton per kilometer. Therefore, my lord, if this empty truck is taken, there is no question of petitioner's quotation is page 126.
Yes.
My lord, will have a look at page 126.
Yes.
It says 74% ASOR for transportation
Yes.
and nothing beyond that, my lord. He did not say he has quoted for 7 kilometers. My lord, if your lordship takes page 124, page 124, my lord,
Yes.
it says the rate for transport of food grains, etc., is on the basis of net weight of food grains, which includes so and so. My lord, net weight of the food grains.
Which include all taxes, duties and
Condition. That's different, my lord, but net weight of the food grains.
Okay.
And then clause 3 says transport charges are payable for distance covered by loaded lorries. So, my lord, if the from railway siding to the weighbridge truck does not carry any food grain, the largest single judge Well, in my humble submission, the committee report is not correctly read, my lord, was in right context.
Your committee report is not correct.
No, it is not read in the right perspective, my lord. Committee was asked only to see, maybe he has at the end said it should be 7 kilometers should be considered. That is the committee's finding, but we are not, committee is not the authority, my lord, to make payment. It is the general manager.
So where is your contention that the report of the committee is incorrect?
No, report of the committee is only asked to see the distance and what manner, that nothing beyond that. So it is not necessary that the committee's report, everything should be taken into consideration.
Where is the order for composition of the committee?
Committee composition. My lord, in the report itself, this says the undersigned committee members in pursuance to RO proceeded to principal, but the committees.
This allows
Yes.
My lord, will kindly have a look at page 77 of page 77. My lord, it is true that in the NIT, the distance was given as 7 kilometers. That is the tentative distance. My lord, kindly page 177 clause 2.
77 or 70? Which page?
77 of the paper book, 77.
Yeah,
Lordship got it, my lord.
yes.
Down below, my lord, brief description of what B.
Yeah.
B2, my lord, will kindly have a look. It says tenders must get themselves fully acquainted with the size and location of the godowns vis-a-vis loading, unloading point before submission of the tender and rates quoted by them for loading into unloading from trucks, wagons shall be deemed to have been done after such acquaintances. Once the tender is submitted by the party, he shall be deemed to have fully acquainted with himself with the size and location of the godown vis-a-vis the loading, unloading points, and he shall not be entitled to any compensation arising out of any discrepancy, size and location of
This
the godown.
1.4 kilometer which you are disputing is the distance which is covered by the empty truck for the from the whatever the place go down or something to the way bridge.
Yes, maybe. It goes obviously because there is no there is a private way bridge from railways for weighing the truck. It goes,
Ramudyog, private
Yes.
way bridge was 1.4
my lord,
kilometer away.
it is like this, my
So
lord.
why you are not provided the way bridge at the site itself?
No, there are some railway siding where we have weighbridge, it is a private weighbridge. It is a private weighbridge, we hired this weighbridge, where we do not have any
So
weighbridge.
you mentioned this, you have to cover the distance for this way, for the purpose of taking weight of the truck at some distance, and we are not going to pay anything to you.
No, when it is said that he will be entitled to transportation,
That is
my lord,
unreasonable.
that would be
That is
too far, my lord, because he knows it has to, empty truck, my lord, from railway siding to the weighbridge, it is, the truck is first weight. Then it
Should
goes
have
to the,
provided Then and there, way bridge.
now there we do not have any weighbridge, my lord.
So that's why only you don't have any bridge, and now you ask the person to go and get the weight of the truck there and will not pay you anything for that.
No, we'll not, my lord. If the contractor has agreed to the terms, that I'll be entitled to, my lord,
Can't be
lordship,
unreasonable. It's a hidden-
what is relevant is, my
it's a
lord,
hidden condition.
no, my lord, what is relevant is what the parties,
So why is the dare weight required to be taken?
my lord,
Why is the dare weight required to be
my
taken?
lord, the truck first goes to the railway siding, reports to the railways, as per the terms of the contract, he used to report to the railways, there is officer there. For every day, previous day, he will be given how much transportation he has to make. Next day, the indents are given. Next day, he goes to the railway siding, reports. Then the truck is sent for weighing first, tier weight. And after weighing, the trucks again goes to the railway siding, and then the food grains are loaded.
So you send the truck for weighment after it reports to you. So that means moment it reports to you, it comes under your jurisdiction. You send the truck for weighment 1.4 kilometers.
No, this is
It
agreed
comes
term.
back.
He knows it.
See, you send it comes back 1.2. You are actually, he travels 2.8 kilometers, but you're only paying him 1.4.
No, my lord, right, your lordship is right, absolutely right. But my lord, payment as per the terms are only the net weight.
There you have mentioned that after reporting, you have to go in so and so way bridge. And thereafter you will again have to come, and we are not going to pay anything to you.
No, that is, I think, my lord, clause 2 that I have read, my lord, must be clear, my lord.
Must be clear
My
or
lord,
clear?
and my lord, it is not
Must
that the
be- Must be
my
clear
lord,
or clear?
every contractor is being paid like that. It is not that, my lord,
Every contractor may be.
my lord,
every
he is
contractor
citizen,
is
and my
not-
lord, he could have raised this, he has already raised to the
In fact,
grievance.
in fact, you are encouraging some type of this corruption in this by doing this. Okay, you have your weight, whatever it may be you want, but will not pay you, and you have some other 2.4 kilometer, he is going to give from his pocket.
My
What he
lord,
will get out of
my
it?
lord, my submission is, when he quotes his rate, he takes that into consideration and then quotes. He takes that into consideration. Because it is but the party, the terms has to be interpreted in the manner where the parties has understood at the time of
You have
entering.
already paid the amount.
We have paid, my lord, because there is an order. And since it will have an effect in many other similar contract, that's why, my lord, we have fine.
clarify it in the further contract that we are not going to pay so and so. Clear,
That's right, of course.
but clear it.
True,
Then
well,
only
because
will be saved.
This,
Otherwise,
because it happens like this MTF is being followed throughout the country very uniformly.
change it. If you are facing this problem, change it.
Well, after all, it is a public money, Manoj. And he could have, it is a contract, Manoj. He has approached factually to the grievance redressal committee, which is provided in the contract. Before the GRC could decide, he has approached the,
Yes. Order is it? Order is it?
Item 11.
May I please, your lords? My lord, the issue here is that basically disciplinary proceeding was initiated before my retirement, and it was even concluded before my retirement with a punishment that the pension has been limited to 50% and the whole DCRG has been withdrawn. Now, the moot question come here, my lord. The learned single judge has converted, set aside the penalty order and converted the whole procedure under Rule 21A. So Rule 21A, the condition precedent under Rule 21A is that, number one, the governor has to issue that order, number one. The court cannot, my lord. Number two, my lord, there must be a so-called notice before issuing the order under Rule 21A
Show cause notice for what?
to the incumbent, my lord. Regarding that,
Initiation of.
yes, my lord, initiation of
But those
conversion.
things were already initiated.
No,
It was
my lord.
concluded.
There are judgments, my lord. I'll proceed, produce the judgment. And the number three is that there must be a pecuniary loss, my lord. Because the conjunctive add in the proviso, my lord, if Lordship, kindly have a look at the proviso first.
Yes. give to me.
Assam Services Pension Rule. Page 10, Rule 21.
Yes.
So Rule 21 starts with the governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government if in a departmental or judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment, shall after the final retirement of the officer be deemed to be a proceeding under this rule and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. This has been cleared, the issue has been cleared by our Honorable High Court, Division Bench of our Honorable High Court, passed in 1988, my lord. But, Riazuddin Ahmed versus State of Assam, my lord. My lord would find the issue number 1 in the front page itself. Whether Rule 21 of Assam Services Pension Rules 1961 authorizes the governor to withhold or withdraw a pension for any purpose other than the recovery of pecuniary loss caused to the government by the pensioner during his service. Number 2, whether a departmental proceeding against a retired government servant can be continued after his retirement under Rule 21A of the Assam Service Pension Rules 1961, even if it does not involve any pecuniary loss to the government. Next, my lord. Para 3, my lord.
Yes.
There, married, my lord. Para 3, my lord. There cannot be any dispute that master and servant relationship between the present petitioner and the respondent state of Assam has ceased with effect from so and so, that is the date of retirement. In view of the well-settled law that a disciplinary proceeding can be drawn and continued against a government servant only when he is still in service, the proceeding in question which was drawn up on so and so against the petitioner and decided to be continued by the state in view of the letter of the Deputy Secretary stated above, we are of the opinion that the said proceeding can be continued only if it is covered by Rule 21 of the rules, as the said proceeding cannot be continued otherwise as the relationship of employer and employee has come to an end. The condition precedent before continuing, Rule 21 should be covered, my lord. My lord may kindly come to the para 5, my lord, next. My lord. The said rule, namely Rule 21A, came up for consideration before Division Bench of this court in Sri Girija Kumar Phukan versus State of Assam and others, 1984 to GLR 488. And after considering the said rule and also decision of Apex Court, this court held as follows. For the foregoing reasons, we entertain no doubt about the position of Rule 21 of the pension rules does not contemplate or authorize automatic continuation of any pending disciplinary proceeding against a retired government servant. There cannot be an automatic continuation, my lord. Indeed, according to us, condition precedent for continuance of the proceeding in terms of Clause A thereof is a decision of the competent authority, namely Governor of Assam, to take action against the person concerned under Rule 21. That apart, before pending a proceeding can be continued, after retirement of a government servant, a so-called notice must be served on him, apprising him of the decision and the action proposed to be taken in terms of Clause A of Rule 21. Reasonableness of this procedure would, however, further mandate these requirements to be fulfilled in a reasonable manner and within a reasonable time. Next, my lord may come to direct para 7. My lord, next paragraph 7, my lord. We have considered the provisions of Rule 21 of the rules, and on close scrutiny of the said rule, we are of the opinion that the right of the governor of Assam to withhold or withdraw a pension or a part of it, whether permanently or for a specified period, is in connection with the right of the governor for recovery from the pensioner, the whole or part of any pecuniary loss caused to the government. In other words, we are of the opinion that the government can exercise this right under Rule 21 only for the purpose of recovery of any pecuniary loss caused to the government and for no other purpose, only for pecuniary loss. This is clear from the intention of the rule makers, as the rule makers were aware that after retirement there was no relationship of employer and employee, and as such, the government can only recover from a retired government servant any pecuniary loss that might have been caused to the government while the employee was serving under the state. Accordingly, the framers of the rule have used the conjunctive ad and in the said Rule 21. This Rule 21 cannot be invoked for any other purpose. Though the learned government advocates strenuously urged that if in a departmental proceeding it was found that the government servant was guilty of grave misconduct or negligence in discharge of his official duty during the period of his service, the government can order withholding or withdrawing of pension. We are unable to accept the said contention of the learned counsel as the relationship of employer and employee ceased on the day of the employee retired from service on superannuation. We further hold that for any misconduct or negligence committed by an employee during his period of service, no punishment may be by way of withholding or withdrawing of pension is permissible under the law after an employee has retired from service. So thereafter, para 10, it was stated that it is really unfortunate that the state could not complete the departmental proceeding during the long period of about 10 years. In our opinion, such action of the respondents smacks unreasonableness, so and so, so and so. My lord, the basic thing is that so condition precedent before going for
Order
rule,
from the governor
yes,
and pecuniary loss.
yes. And in my case, the court has converted it, learned single judge has converted the proceeding to Rule 21A. That cannot be done because it's the power of governor, number one. Number two, my lord, in my, if your lordship look at my charges, my lord, so cause notice, my lord will get at page 50. Sorry, my lord.
48.
48, my lord. Charge number 1, my lord. It appears that while you were serving as executive engineer, so and so, it is found that you have paid mobilization advances and equipment advances to contractor against bank guarantee of Udyogik Samobai Bank Limited, Jorhat, which was found to be not a bank as per report of the RBI. This reveals that the payment of advances to the contractor was made without safeguarding the interest of government and in violation of PMGSY guidelines. You are therefore charged by violating PMGSY guidelines and negligence to government entrusted duties. Charge 2, my lord. It appears that while you were executive engineer, so and so, it is found that although the contractor stated the construction of roads, so and so, to so and so, including cross drainage works and routine maintenance of works in February 2009, the progress of the work being very slow, you have terminated the work in July 2010, as a result of which the advance amount could not be recovered, which led to a loss of government money. The charge number 2 basically is related to the pecuniary loss, my lord, and that has not been proved, my lord. If your lordship have a look at the findings of the inquiry report, inquiry officer, my lord, at page 65, my lord. Page 65, my lord, got it. May I read, my lord? I have carefully read the charge number 1 framed against the charged officer along with the aforementioned documents furnished with the government notification dated 29/10/2015. I have meticulously perused the bunch of documents submitted by the presenting officer, which are tender documents containing the bidding documents as well as the agreement pertaining to PMJSY package number so-and-so in Morigao district, Assam. The careful reading of the said documents brings to light the following provisions of the contract. The section 4, part 1 of general conditions of contract in clause 1.1 defines the engineer as follows. The engineer is the person named in the contract data so-and-so, or any other competent person appointed by the employer and notified to the contractor to act in replacement of the engineer who is responsible for supervising the execution of the works, administering the contract. Engineer as per contract data is executive engineer PWD or who is the charged officer. As per clause 45.1, the agreement of contractor shall submit bank guarantees issued by the commercial bank. So bank guarantees should be submitted to the chief engineer, not to the executive engineer, my lord, as per 45.1 clause. The above provisions make it clear that the role of charged officer insofar as the contract in question is concerned was for supervising the execution of the works and administering the contract. So whether administering the contract includes verification of the documents? No, my lord, because administering the contract, executive engineer has some other role.
So charge number 1
Two.
is proved and charge number 2 is not proved.
Proved, my lord. Charge number 2 is not proved. My lord will get at page 66. Charge number 2,
Not proved.
not proved. So basically, since there is no pecuniary loss, so the disciplinary proceeding converting under Rule 21A also cannot be, cannot be done, my lord. That is my humble submission, my lord.
Yes, Mr. Nath?
Well, the decision which my learned friend has placed, the Girija Phukan's decision, in that case, the show cause was issued in 1975 in paragraph 3, and the person concerned retired in the year 1983. For last 10 years, the proceeding was not completed. But in our case, kindly see, the show cause was issued in 2000. He was placed under suspension in 2015. Show cause was issued in July 2015. And the penalty order was ultimately after the DP was passed on 3/3/2017 in 2 years. In the learned single judge, while passing the judgment in paragraph 18, has clearly recorded the reason that section 21 of the pension code is a legal fiction. Kindly come to para 18, Malad. It's a legal fiction because the matter was before your lordships and the
Yes.
Well, under the normal circumstances, if the disciplinary proceeding is initiated and could not be completed till the retirement, then if the authority wishes to continue with the DP under Rule 21, then my lord, a show cause notice has to be given to him that we have decided to proceed with the DP even after your retirement, and the notice under that rule is required. Here is a
Who
case,
is supposed to give that notice?
the disciplinary authority, my lord, the ultimately it is under the Rule 21, Rule 21, the Governor of Assam reserves to himself the right of withholding or withdrawing the pension or any part. The final decision will be in the name of the Governor, my lord. And this disciplinary authority has to express their mind that we want to proceed with the disciplinary proceeding even after the retirement. And this is the circumstances, my lord,
Without notice, they can't continue.
without notice. My lord, that is in the normal circumstances. But here is the case, my lord. The disciplinary proceeding was concluded on 3/3/2017, and the person concerned retired on 31/3/2017. Then, my lord, the writ petition was filed challenging the 3rd of March 2017, the order of penalty. And while disposing of the matter, kindly, my lord, come to paragraph 18 of the 18 of the judgment, my lord, 105, my lord.
Yes.
My lord, the honorable court has said that we have interfered with that penalty order on a technical ground. A reading of the provision of Rule 21A of the rules of 1969 makes it discernible that in the event the Governor of Assam would like to reserve himself the right of withholding the pension or any part of it, if in a departmental or judicial proceeding, the petitioner is found to be guilty of grave misconduct or negligence during the period of service, such disciplinary proceeding, if instituted while the officer was in service, shall after the final retirement of the officer be deemed to be a proceeding under Rule 21A and shall be continued and concluded by the authority by which the proceeding was initiated in the same manner as if the officer had continued in service. In other words, Rule 21 of the rules of 1969, there is no such embargo as regard the period that may be elapsed from the date when a government servant had retired from the service. All that Rule 21A provides is a legal fiction that if a departmental proceeding has been initiated but could not be concluded, and in the meantime the government officer retires from the service, there is a deemed provision that the said proceeding henceforth from the date of retirement would be a proceeding under Rule 21A of the rules of 1969, and it would be continued by the disciplinary authority who had instituted the disciplinary proceeding and bring an end to the same proceeding as if the government servant had not retired from service. On the other hand, Rule 21B provides that if the departmental proceeding contemplated under Rule 21 was not initiated while the officer was in service in such event, as per the provisions of Rule 21B2, it shall not be instituted in respect of any event which took place more than 4 years before such institution. The embargo of 4 years for institution of a disciplinary proceeding after retirement would be applicable only in such cases where the disciplinary proceeding had not been instituted. But on the other hand, if the disciplinary proceeding had been instituted, it would be covered by the provisions under Rule 21A. That is, there would be a legal fiction that it would be deemed to be a disciplinary proceeding would now be continued as a proceeding under Rule 21A. Similarly, the provisions of Rule 21C that such a judicial proceeding also cannot be instituted in respect of a cause of action, that it is not applicable for our case, Malon. In the instant case, kindly see.
Do you have this copy of the pension rules?
Yes, my lord, I have.
Yeah. Rule 21.
Yes, my lord.
There is one explanation added in the year 1989.
Yes, I have seen that.
What is this? What is
While
this?
Well, the continuation of proceeding after the final retirement of the officer shall be automatic under sub-rule so and so, and no fresh decision of the governor and so, or the appointing authority, nor any so-called notice to the person concerned shall be necessary. The powers under Rule 21 shall be exercisable, not only in case of causing pecuniary loss to the government, but also in all other cases. The explanation is that.
Girija Phukan is a decision.
What is the-
But that decision, which is holding the field today also, my lord.
Sir, that is in context of unamended rules. This explanation was not there in the rule book when this judgment was given.
My lord, it's regarding to Rule 21, my lord.
Yes. It was in the year 1989 only.
Yes.
And Mr. Nath, you are not supposed to argue on this. What kind of supporting the judgment? This explanation is very
Lot
clear.
of, lot of.
So you are not aware of this explanation.
No, it is there, Lord.
It is there, then why you are not arguing this? It's too much.
My lord,
Yes.
my lord, Mayor inserting an explanation cannot overrule the judgment, my lord.
Certainly, can you can ऐसे थोड़ी है अभी you are please don't we have to here inserting an explanation will not overrule the judgment. With the amendment of the statutes, the judgments have always been overruled.
My
In
lord,
Shabano case, we are not aware of that.
even if can continue automatically, my
Shabano
lord.
case, what
My lord, I understand, my lord. Even if it can continue automatically, my lord, then also the learned single judge has no power to exercise that to convert the proceeding, disciplinary proceeding to Rule 21.
single judge would have done.
My lord,
Since you have retired,
my lord,
the learned single judge has said that. The learned single judge has simply interfered because the punishment was awarded beyond his whatever the jurisdiction.
my lord.
Therefore, he said, okay, now from this onwards, the proceedings will go into Rule 21. That's all. And there's a right conclusion.
But the power can be exercised only by the governor, my lord. The converting power, my lord.
Is automatic. This explanation clarifies everything. Unfortunately, the state has not argued this.
My lord,
And if the learned single judge would have taken into consideration this explanation, इतना लंबा चौड़ा इसको justify करने का जरूरत नहीं था. That's all.
my lord, that's all.
Order reserved.
That's all, my lord.
Mr. Nath, तुम रूल बुक खोल के देख भी लिया करो, पढ़ लिया करो.
Item 12,
Your lordship, on last two occasions also she has not appeared. In this case, your lordship,
Sure.
Where is the rules you have taken it?
Lordship,
Bank का जो that secession.
your lordship had asked me to produce the rules.
है ना,
So it's here, your lordship.
You have it.
Yes, your lordship.
देखा था। The concept of the respondent is note to you.
Yes, your lordship.
Where is she now?
Lordship, if your lordship permits, then I can give a poll to her.
Ask, madam,
Lordship,
that next time,
I'll ensure your lordship.
and make it sure, whenever the next time matter is listed, inform her in advance.
Lordship.
Can you make a photocopy of this 2.6 onwards till page 71, 72 and 73?
Lordship.
Keep it on record.
Lordship.
So,
ये जुलाई में when present on behalf of the responding, list this matter. Responding, list this matter in July.